Thanks, David. We now have Joshua Cohen from Cleveland.
I suppose I better begin with a confession. I am a contingency lawyer working for a city for a fee, and I'm looking for a fee. But let me just address that preliminarily and tell you why I don't think that that arrangement compromises the integrity of the government's role. I am the lawyer on the case. I am not the client. The city's law director is co-counsel in the case. I do not make, and it's part of the contingency fee agreement, major decisions on how the case proceeds. I don't decide whether to drop cases, whether to make settlements, whether to, any major strategic decision belongs to the client and really ultimately to the mayor. There's already been one example in the case that I'm handling, which relates to, it's a public nuisance case relating to the subprime foreclosure crisis, where the mayor's political considerations, I think, overrode what the legal advice was. So I do think that there is a check on the lawyer's personal interests, which I don't think are any more at play than in any situation. Hopefully that for contingency lawyers, that isn't the overriding consideration in performing their jobs, that it would be unethical. But also that you also have to consider a very practical consideration here. Without a contingency arrangement available to the city of Cleveland in this case, the case never would have been brought, because the city of Cleveland simply does not have the resources right now to devote the staff in-house to prosecute a case like this. And without that option, to have contingency lawyers like us outside, they would never have been able to mount this challenge. Now, the case that we filed for the city was filed in January, January 10th, and it accused 21 leading securitizers, financiers of subprime mortgage, of creating a public nuisance by financing subprime lending in the city when they knew or should have known that doing so could only result in the foreclosure crisis that has since come about. The recovery the city is seeking is to recover the municipal costs that it has incurred and lost tax revenue attributable to the foreclosures that we can tie to the defendants. Things are bad in Cleveland. This is not City Hall, but let me show you. You cannot overstate the seriousness of this foreclosure crisis in Cleveland. This chart shows that by 2007, there were over 7,500 foreclosures in the city. At the beginning of this decade, Cleveland was a national leader in neighborhood redevelopment efforts. That's no longer true. There were 7,500 in 2007. This year, at least a like amount. And this next slide shows that it's pretty much affected the entire city. There was a study by a local university, Case Western Reserve, that tallied that by the beginning of 2008, there had been over 22,000 foreclosures in the city during the decade, most of which were in the last 4 or 5 years. As of November 2007, a little more than a year ago, there were more than 7,000 vacant and abandoned residences in the city, which represented more than 5.5% of the total housing stock. And the situation has gotten much bleaker since then. All of this is very much a subprime phenomenon. Between 2005 and 2007, a full 84% of all foreclosures involve subprime mortgages. Subprime lending in Cleveland just don't mix. Already, by the beginning of this year, a full 1/3 of the subprime loans made in Cleveland had already gone to foreclosure. 1/4 of the subprime loans made in 2006 had already gone to foreclosure. You can imagine those statistics have increased during this year. The cost for the abandoned homes that result from these foreclosures can be considerable for the city. It includes things like maintenance, mowing the grass, rodent control, and the like. There's increased fire and police protection that is required for these properties. Demolition costs. The city spent a full $10 million in 2007 demolishing homes. They're going to spend at least $10 million this year in doing it. There was a study that was conducted for the year 2006 that said the city lost $35.5 million in connection with foreclosed and abandoned homes. That figure is low compared to the years that have ensued for two reasons. One is that year there was only $1.2 million spent on demolitions. As I've said, the figure's gone up. And the lost tax revenue that they calculated for that year related only to the demolished properties. Well, we know in the scholarship that has taken place recently is pretty clear that abandoned foreclosed homes affect property values of surrounding properties as well, and diminished that part of the tax base. There was a study done by the Center for Responsible Lending in Philadelphia that was released last year that suggested that in Cuyahoga County, where Cleveland sits, that there was a loss in tax base of $462 million of property just based on its proximity to foreclosed property. The city is expending exceedingly more to deal with these foreclosed homes based on exceedingly less in revenue that it's receiving based on this same problem. Now, there was this big debate that goes on the talk shows and things about who's responsible for the foreclosure crisis. Were the lenders making financially irrational loans, or were borrowers being irresponsible and taking on loans that they knew that they couldn't pay? Without resolving that, one thing that we can say definitively is that the city was an innocent bystander in all of this. The city could not and did not regulate these loans. They made no money from these transactions, yet they are left holding the bag for millions upon millions and millions of dollars in costs relating to the foreclosures and the abandonment of this property. From a broad perspective, the responsibility for all this lies on the securitizers, the financial institutions that created a secondary market for subprime mortgages. The case focuses on the period that begins in 2002, 2003, when money began, what we say, the phenomenon described as money began seeking borrowers. That's when the financial institutions, the financiers, began going to lenders and saying, look, the public, the investing public is just eating up our mortgage-backed securities. We need you to get more mortgages. And that's when they started telling lenders what type of loans to make and the quantity. And we believe that recent events, will show how deeply involved Wall Street was in all of this. And we think that the facts will show that, will corroborate that level of influence. The city is asserting a public nuisance theory, and the critics of the case, as well as the defendants, are trying to cast the case as a direct descendant of the products liability cases that cities have been prosecuting over the last 20 years, the tobacco and the firearm and the lead paint cases, which of course would pretty much doom the case given what's going on with lead paint over the last year. In fact, the Ohio General Assembly had already pretty much limited the availability of public nuisance cases in products liability cases before Cleveland filed the suit. Subprime mortgages don't qualify as products, so that took us out of that prohibition from the statute. But there are other things that significantly distinguish the Cleveland case from these product liabilities cases. For one thing, the city is not trying to establish any sort of market-wide or industry-wide collective liability on the defendants. We're just not doing that. The second thing, as I'll explain a little more later, is that the claim that we're asserting is unique under the city itself. It pertains to Cleveland's unique financial situation, and it's not something that would pertain to other cities, maybe one or two, but not other cities at all. There have not been any copycat suits that have been filed since the city of Cleveland filed this case, even though it has generated a lot of national, international media attention. The city is also not asking the court to recognize some sort of newfangled public right as part of the nuisance claim. The city filed its case on the basis of abandoned, deteriorating homes that result from the foreclosures attributable to the defendants. That sort of blight is the essence of public nuisance law. We're not asking the court to find a right to live free of, in a smoke-free environment, or live free of the threats of public danger, or a right to be free of gun violence. This is something that is well established in the law. As a matter of fact, it's statutorily recognized in Ohio that blight of this sort constitutes a public nuisance. Now, nuisance is a negligence-based theory, and so what we're going to have to be able to show is that these financiers, the defendants, either foresaw or should have foreseen that financing subprime mortgages in Cleveland would lead to the foreclosure crisis that eventually ensued. And to evaluate that prospect, I have to get into a little about the expectations that fueled the subprime boom generally. The housing bubble is what served as the essential justification for this, mad lending. No matter how irrational a loan was, or so the hypothesis went, the appreciation in the value of the collateral eliminated risk from the transaction. So what? We make a loan to someone who's not really qualified. If they default, the value of the house has gone up, so we haven't lost anything. And because it's going to continue to appreciate, there'll be another buyer willing to come in and take it over. That theory never could have applied in Cleveland. There was not ever a housing bubble in Cleveland. You can see that while the nation experienced great appreciation in the value of the houses, Cleveland, the market remained essentially flat. As a matter of fact, at the beginning of the decade, when the housing bubble was taking place elsewhere, Cleveland was already experiencing a mini foreclosure crisis of its own. And that's not hard to understand. Cleveland at the time had an extremely stagnant economy. It was a Rust Belt city where the manufacturing sector was fizzling and there was no replacement that was immediately emerging. It also was an extremely poor city. As you can see from these statistics, there were a lot of low and moderate income households, very few high income households in the city. And next slide shows also that in terms of median income and poverty rate, we ranked at the wrong end of both of those statistics during the pertinent period of time here. So what the injecting subprime financing in a big way into Cleveland during 2003-2004, the financiers were creating sort of a perfect storm. They were making credit available at higher than average interest rates to borrowers with worse than average credit, doing so in a flat housing market with no meaningful influx of new buyers, under economic conditions that afforded borrowers little economic opportunity, little employment opportunity and mobility, and where the future remained murky at best. There are very few cities, if any others, in the country that can claim that set of circumstances. We have to be able to show that those circumstances enabled the securitizers, the financiers, to foresee or be able to say that they should have foreseen, in light of those, that subprime financing would lead to the foreclosure crisis. Cleveland's economic situation was no secret. I mean, the fact that it was a poor city was no secret. And you got to remember that the investment banks were largely in control of the composition of their mortgage pools. They were buying in this period of time. They also were in the business of assessing risk of the products they sold to investors, and that would have entailed projecting default rates, foreclosure rates, and doing so on the basis of the geographic composition of their mortgage pools. We have just been hit. Let me just tell you real briefly that the procedural posture of the case, it started in state court, it was removed to federal court. Motions to dismiss are now pending. The issues that have been raised are the ones that come directly from the Rhode Island decision, that we have failed to allege interference with a public right. We failed to establish or allege proximate causation. There are also federal preemption issues based on the federal banking laws that we have to deal with. Just as a final note, I'll say that there was a second lawsuit that the city filed last summer in state court that deals with two different theories, one of which is a state RICO claim based on the inaccurate filings that the banks have been making in suing for foreclosures, the situations where the banks don't actually have title to the mortgages and notes on which they're foreclosing. So the briefing on the motions to dismiss should be done in February, so hopefully by next summer we'll know if it's a thumbs up or thumbs down. Thank you.